Today we're going to talk about what I call parentage cases. This is similar to a divorce, except in these cases the parties aren't married. For example, boyfriend, girlfriend live together for a year or two, uh, decide to have children, and then something happens down the road, year or two, they separate. Now they need a parenting plan to determine custody, child support, not property, no property issues because they're not married. So those property issues would be dealt in a different action. In this action, only child support and residential time would be decided. Now, and they come in two flavors, like divorces do, and we talked about that in the earlier video, contested and uncontested. If your parentage case is uncontested, then it's very much like the uncontested divorces that we discussed in the prior video. If it's contested, it's quite different. So in contested parentage cases, the father does not have any rights to see the child until he files a petition to establish parentage. In most jurisdictions, there's a statute that allows the mother to be the parent or to have custody of the child if she's unwed. So it's important that the father file the petition, or the mother could file the petition either. But the father has no rights to see the child until that time. Now, sometimes what happens is the mother will go to the Title 40 child support office, begin a child support action against the father, and get child support set. But that court has no jurisdiction over custody, just child support, just the money. So again, it's important that if custody is an issue, that the petition to establish parentage is filed. Once that's filed, then these issues can be addressed in court. We aggressively represent our clients. When we file these petitions, we file it with discovery as well. This discovery is an important piece to the action because of the information it provides for us. It's not a lot of lawyers do that, but we do because it's just a better way to represent your client. So once we file it, with the filing and then that person served, there'll be a court date. That court date's called a pendente light hearing. It's a temporary hearing where child support and custody or visitation time is set. At that hearing, you'll be able to put on witnesses, primarily yourself, depending on which court you're in, to establish why you want residential time with the child, who's had residential time with the child. If you've had residential time, how much have you had? There's about 12 or 13 custody factors that go into the court's analysis on custody, on visitation. Child support is addressed. Child support is determined by a child support calculation, by computer calculation. It takes into account the father's income, the mother's income, how many days the children are going to be with the father, how many days they're going to be with the mother. Other inputs are daycare information. Who's paying the daycare? How much it is? How much is it? Daycare is very important. It's a dollar for dollar credit on the child support worksheet. Who's paying the insurance? That's also a credit on the child support worksheet. So each one of those factors are factors that can be litigated in this temporary hearing. So it's important that you have good representation, uh, with attorneys that are familiar with these type actions to get these numbers where they should be. Without good representation and challenging the other side's numbers, um, then you could end up with an adverse ruling on the child support. Once you have a temporary hearing, then you complete the discovery process. Uh, at the end of the discovery process, while the discovery has been um, propounded and submitted, then your case is eligible for to go to mediation. Most courts are requiring you to go to mediation before you go to trial. Mediation, what is it? It's an extraordinary process and it's extraordinarily effective. Um, it's typically at a mediator's office that's trained in mediation, and the mother and her attorney will be in one conference room. The father and his attorney will be in a different conference room, and the mediator will go back and forth between conference rooms to find out what the parties are there to accomplish. And then at some point, the mediator will relate that to the facts of the case, and then relate that then to the particular law or what the court is likely to do in that case, and try to get this case settled. Uh, these mediations are very effective. They're amazingly effective. Hardly ever does any case not get settled, but you'd have to have a mediation usually before you go to trial. And that's kind of the short version of what a parentage case is about. We do these kind of cases every day. Let us know if we can help you.